And one of the last sections, so we've been talking about how to get a patent and stuff like that. Let's set that aside. And let's do the same thing we did on the trademark side. Now let's start looking at if you put a product or a process out in the marketplace, do you know if your competitor has a patent that can exclude you from doing what you want to do? That's the basis of patent infringement, okay? Again, you're not going to hire me for patent infringement. So I'm on the prosecutor side. But I do think that it's beneficial if you have good counsel in this area. Specifically on the patent side, because if you put out a product and you have some form of profit from selling that product, if you're considered what's called a willful infringer, you don't just have to hand over your profits to whoever is the patent owner. You might have to hand over 3 times your profits to whoever the patent owner is. It can put you out of business. Okay? So it is definitely an area where you need to have good counsel. All right, we're wrapping up here. So we have clearance searches. These are some of the things that you have to consider when you're putting a product out into the market. It's also known as a freedom to operate opinion. I don't know if you've heard those terms, one of those terms or another. You need to know who else is out there, who else has patents in your space, what they're doing, and how your product or your process is in effect relates to their patent. Really the term that people use is if a patent reads on, if the claims of a patent read on to your product or process. I don't know if you've heard those terms or not. If you're at that point where you're doing this sort of analysis, you need to know, all right, how do I change what I'm doing? How do I modify what I'm doing so others' claims do not read on to what I'm doing anymore? Okay? And that's what I'm talking about there. We talk about the features of your invention being modified. This also leads to better design product or process. And like we were talking about being a willful infringer, it can help lower your level of liability. If, for some unfortunate reason, you already have your competitor sending you a cease and desist notice, right? Then it's time to get an opinion of counsel, whether it be infringement, non-infringement, which is preferable under that scenario. If, on the flip side, you're the one who has the patent and you're going after someone else, then you want an opinion of counsel saying that they are infringing. Why, right? And finally, invalidity is another way of getting out of this patent jam. This is a little information about me, particularly. Went to law school 2005, became a patent attorney 2006. And this is something about my years of experience. Okay? So I kind of cruised through that pretty quickly. Hopefully we have a few minutes left here.